His attorney went silent mid-sentence. Not a pause, not a stammer. A full, breathless silence that stretched so long I could hear Lawrence set down his glass on the other end of the line. And then, very quietly, the attorney asked him one question. Just one. And my father, the man who had smiled at me across an estate attorney's conference table 8 months earlier, like he'd already won, couldn't answer it. I heard him exhale, long and slow, like something deflating. And me, sitting in my car in a parking garage 3 miles away, I closed my eyes and I let myself feel it, just for a moment. Then I drove home. But I'm getting ahead of myself, because you need to understand how we got here. How a woman who sat through a will reading with her hands folded in her lap and said absolutely nothing had actually been 3 steps ahead of everyone in that room for 2 years. How grief and precision can live in the same body at the same time. And how the most dangerous thing my father ever underestimated wasn't my mother's estate. It was me. My name is Kathy Brinkman. I'm 32 years old. If you want to know how a quiet, precise woman dismantles her own father's plan without raising her voice once, stay with me. This story goes exactly where you think it does, and then somewhere you won't expect. Make sure you're subscribed so the algorithm doesn't bury the ending on you. My mother used to say that numbers don't lie, people do. She'd tell me that while we sat at the kitchen table on Sunday mornings, her reading glasses low on her nose, a cup of tea going cold beside her, as she worked through whatever document needed her attention that week. A lease renewal, a contractor's invoice, a property tax assessment she wanted to verify herself before she trusted anyone else's math. I'd sit across from her with my homework, and I'd watch her, and I understood something early that most people take decades to learn. That real security is not inherited. It is built, carefully, one decision at a time, by someone willing to do the work no one else wants to see. Eleanor Brinkman built things, not in the way that gets you written up in business profiles or photographed at charity galas, in the quiet way. The way that starts with one small commercial unit on the edge of a neighborhood everyone else had written off. Purchased when I was 7 years old with money she had saved over 11 years of working as a medical billing specialist. She researched that purchase for 8 months before she made an offer. I know because I found her notebooks after she died. Spiral bound, filled with her handwriting, every comparable sale in a 3-mile radius, every zoning variance, every projected rental yield. 8 months of Sundays at that kitchen table before she signed a single page. By the time I was in college, she had 3 properties. By the time I graduated, 5. A small portfolio by any serious investor's standard, but clean. No over-leveraged debt, no partners whose intentions she couldn't verify, no exposure she hadn't modeled herself. She managed the leases, handled the tenant relationships, reviewed every maintenance contract. She did not delegate the things that mattered. Lawrence called them our investments at dinner parties. He said it the way men sometimes say things, casually, inclusively, as though the pronoun erased the question of who had actually done what. My mother would smile and refill someone's glass and say nothing. She had a gift for that, for letting people believe what they needed to believe while she kept the real ledger in her own head. I am my mother's daughter in exactly that way. I became a forensic accountant because the work made sense to me in the same way those Sunday mornings made sense. It is the discipline of looking at what is actually there, rather than what someone has told you is there. Of reading a document the way it was written, not the way it was meant to sound. My colleagues find it tedious. I find it clarifying. There is something deeply settling about a number that has nowhere to hide. Lawrence thought he was taking everything my mother built. He had no idea that everything my mother built included me. My mother died on a Tuesday in November, quietly, the way she had lived, without making a fuss about it. Pancreatic cancer. 4 months from diagnosis to the end. She spent most of those 4 months at home, which is what she wanted, and I spent most of them beside her, which is what I wanted, and Lawrence spent most of them making phone calls in the hallway and researching things on his laptop that he'd angle away from me whenever I walked past. I noticed everything. But grief has its own calendar, and during those 4 months I let myself be a daughter first, and everything else second. The funeral was small. Eleanor had asked for that too. Afterwards, in the week that followed, neighbors brought food, and Lawrence accepted condolences with the practiced solemnity of a man who had already moved on to the next agenda item. I watched him the way I watch financial documents, not for what was visible, but for what the structure revealed underneath. The will reading was scheduled 12 days after the burial. I had seen my mother's will. The version she'd shown me 3 years earlier, during one of our Sunday mornings, matter-of-fact and unhurried, the way she handled everything important. It was precise and fair. It left the estate divided cleanly, with the commercial properties structured to transfer in a way that reflected the work she had put into building them. That was not the will Lawrence's attorney produced. The document that appeared on the conference table that morning had been signed 8 months before my mother's death. 4 months before her diagnosis, during a period I had no reason at the time to examine closely. It left Lawrence the primary beneficiary of the estate in full. The properties, the LLC, the accounts. Everything she had spent 30 years building. To me, it left her jewelry, her books, and a sum that would have felt generous if I hadn't known what it was standing next to. Lawrence watched my face when the attorney read it aloud. I know he did because I felt it, that particular quality of attention from someone waiting for a reaction, waiting to see the moment you understand you've lost. I kept my hands folded on the table. I kept my breathing even. I asked one procedural question about the probate timeline, wrote the answer in my notebook, and thanked the attorney for his time. On the drive home, I stopped at a red light and sat with it for a moment. The grief of it. The specific, clarifying grief of realizing your father had been planning this while your mother was still alive. Then the light changed and I started working. I did not hire an attorney immediately. That would come later. What I did first was what I always do when something doesn't add up. I pulled the source documents and I read them. Not the will. The will was Lawrence's problem to defend and an attorney's problem to challenge. What I wanted was everything underneath it. The actual financial anatomy of the estate my mother had spent 30 years building, asset by asset, because I had learned from Eleanor herself that the most important information is rarely in the document everyone is arguing about. It is in the documents no one thinks to request. I started with the flagship property, a 4-unit commercial building on Delwood Avenue that my mother had purchased 17 years ago and quietly tripled in value through patient management and 2 well-timed renovations. I pulled the title history, the county assessor records, the environmental filings. Standard procedure, the kind of thing a careful buyer does before closing and most people skip. There was a contamination lien, filed 14 months earlier by the County Environmental Authority, attached to the property after a Phase 2 soil assessment flagged residual contamination from a dry cleaning operation that had occupied the ground floor unit in the late 90s. The remediation estimate was attached to the filing. It was not a small number. The lien ran with the property, meaning whoever owned it owned the obligation. My mother had known. There was a note in her records, in her handwriting, dated the same week the filing appeared. She had been in the middle of negotiating the remediation timeline when she got sick. Lawrence's attorney had either not found it or had not looked. I moved to the tax records next. The LLC, Brinkman Property Holdings, which my mother had formed 12 years ago as a cleaner vehicle for the portfolio, had deferred a significant federal tax liability across 3 consecutive filings during a period when the business had carried losses forward. The deferral was legal and properly documented. It was also 4 years overdue for resolution and accruing interest at a rate that made the original figure look optimistic. The LLC's internal liability register took me another 2 evenings to reconstruct from the operating records. A dormant vendor dispute from a contractor my mother had terminated for cause. 2 unresolved insurance subrogation claims. A promissory note she had extended to a former tenant, now in default. None of it was hidden. All of it was real. All of it would belong, entirely and legally, to whoever accepted the estate in full. I closed my laptop at midnight and sat in the quiet for a long time. Then I made a list. It was the Sunday notebooks that told me first. I had taken them home after the funeral. 7 spiral-bound notebooks spanning nearly a decade of my mother's financial thinking. The The same ones I had watched her fill at the kitchen table while my homework sat across from her. I had boxed them up with the intention of keeping them simply because they were hers, because her handwriting was in them, because throwing them away felt like losing one more thing. I did not expect them to be a roadmap. The last two notebooks were different from the earlier ones, less operational, fewer lease comparisons and contractor bids, and more architectural. She was thinking about structure, about what the portfolio would look like after her, and more specifically, about what it would look like without the complications she had clearly begun to anticipate. The entries were spare and deliberate, the way my mother was spare and deliberate when something mattered. She didn't write in full sentences when the thinking was serious. Just figures, legal terms, questions to herself, and occasional names. Her estate attorney's name appeared in the final notebook 11 times. I called his office on a Thursday morning and introduced myself. He had been expecting me, he said, with a quietness that told me he had been expecting me for some time. We met that afternoon. What my mother had done was not complicated. It was simply careful, and it was early. 2 years before her death, more than a year before her diagnosis, she had worked with her attorney to restructure the cleanest, most liquid assets out of the general estate and into a revocable trust that converted to irrevocable upon her death, with me named as sole beneficiary. The two properties with the strongest cash flow and the clearest title. The most current and solvent operating account of the LLC. Certain investment holdings she had built quietly over the years and never discussed at dinner parties. The trust predated the revised will by nearly 18 months. That gap was not an accident. My mother had understood, because she always understood the structure of things, that a will can be contested, revised, and manipulated by someone with proximity and patience. A properly executed trust, funded and transferred while the grantor is living and competent, operates outside the estate entirely. Lawrence's attorney couldn't challenge what was never subject to probate. There was nothing to argue. The transfers were clean, the documentation was thorough, and every signature had been witnessed and notarized by people who were not related to anyone in our family. She had built a fortress around the things that mattered most, and she had put my name on the door. Lawrence's attorney was named Gerald Fitch, and he was the kind of lawyer who mistakes aggression for competence. He called me 3 times in the first 2 weeks after the will reading, each call slightly more pressured than the last, laying out the estate's position with the particular confidence of a man who has never had anyone look carefully at his paperwork. The estate was clear, he said. The will was properly executed. Probate would move quickly and cleanly if I chose not to complicate things. The subtext was not subtle. Take the jewelry and the sentimental sum and be grateful. I took notes during each call. I asked clarifying questions in a voice I kept slightly unsteady. I let him hear me pause before answering, the way a person pauses when they are trying not to cry, or trying to think through something they don't fully understand. I thanked him for his patience more than once. My own attorney, a quiet, thorough woman named Patricia Osei, who had handled estate litigation for 22 years and had never once raised her voice in a deposition, found this approach both tactically sound and, I think, privately amusing. The performance had a specific purpose. Gerald Fitch was only as careful as he believed he needed to be. If he thought I was overwhelmed, he would not look harder. If he thought I was defeated, he would not look at all. And the last thing I needed was Gerald Fitch requesting an independent audit of the estate's liabilities before Lawrence had already committed to accepting them in full. 6 weeks into the process, Patricia submitted a formal counteroffer on my behalf. I had calibrated it carefully, low enough to read as desperate, specific enough to seem like I had done some homework, structured in a way that implicitly accepted the will's validity without actually conceding anything of legal consequence. It was, in the technical sense, a losing offer. That was the point. Lawrence rejected it within 48 hours. Patricia forwarded me his attorney's response letter, and I read the relevant line twice. The estate's position was firm. My counteroffer demonstrated, in Gerald Fitch's words, a fundamental misunderstanding of the asset values involved. They would not be entertaining further negotiation on the core holdings. I read that sentence and thought about my mother at the kitchen table, about the 8 months of notebooks before she bought her first property, about the particular discipline of knowing exactly what you have and saying nothing until the right moment. Lawrence thought he was watching a woman run out of options. He was watching the last act of a plan that was already complete. The settlement was scheduled for a Wednesday morning in February. Patricia had reviewed the final agreement 3 times and called me the evening before with the particular tone she used when she wanted to make sure I was certain. Not uncertain herself, Patricia was never uncertain, but careful with me in the way good attorneys are careful with clients who are about to do something that cannot be undone. I told her I was certain. She said she knew, and that she would see me in the morning. I slept well that night, better than I had slept in months. The conference room was on the 14th floor of a building downtown, the kind of room designed to make transactions feel significant. Dark wood, leather chairs, a long table that seated more people than were ever actually present. Lawrence arrived with Gerald Fitch and his own accountant, a man named Dowell, who had prepared the asset schedule Gerald had been working from since the beginning. I arrived with Patricia. We sat across from each other the way people sit when they are concluding something. Gerald walked through the agreement with the brisk efficiency of a man who considers the outcome settled. The asset schedule was attached as Exhibit A. The properties, the LLC, the accounts, the holdings, all of it itemized at the valuations Dowell had prepared. Clean figures, gross valuations, the kind of numbers that look impressive until you subtract what's owed against them, which Dowell's schedule did not do in any granular way that would have alarmed a careful reader. Gerald Fitch was not a careful reader. He was a confident one, which is a different thing entirely. At no point did he request an independent audit of the estate's liabilities. Patricia had prepared a response if he did, a reasonable, cooperative, slightly time-consuming response that would have accomplished nothing except delay. He did not ask. Lawrence's accountant had prepared the numbers Lawrence wanted to see, and Gerald had built his case on top of them, and neither man had stopped to question the foundation, because the foundation appeared to confirm what they already believed. I watched Lawrence sign. He used a heavy pen he had brought himself, the kind of detail that tells you something about a person. He signed with the deliberate satisfaction of a man closing a deal he is proud of, and when he finished, he looked across the table at me with an expression I recognized. The same expression from the will reading, the same quality of attention, waiting to see if I understood what had just happened. I held his gaze for a moment. Then I thanked Gerald for his time, gathered my copy of the agreement, and followed Patricia to the elevator without looking back. 30 days after the signing, a disclosure package was sent to Gerald Fitch's office by certified mail. This was not something Patricia arranged. It was not a maneuver or a filing or any kind of strategic action on our part. It was simply a legal requirement, a mandatory creditor disclosure that attaches to any estate settlement of this size and complexity, triggered automatically once probate closes and the transfer of ownership is recorded. The County Environmental Authority needed confirmation of the new responsible party for the remediation lien. The Federal Tax Authority needed the updated taxpayer of record for the deferred liability. The LLC's creditors needed a current contact for the outstanding claims. The disclosure package was, in other words, the estate introducing itself to Lawrence in full, for the first time, in one document, with no one controlling the order in which the information appeared. Patricia told me it had been delivered on a Thursday. She knew because Gerald Fitch called her that same afternoon, not with the measured tone of opposing counsel managing a routine matter, but with the slightly elevated register of a man who has just read something that has unsettled him and is trying to determine, very quickly, how unsettled he should be. He asked Patricia whether we had been aware of the environmental lien at the time of settlement. Patricia told him that all information material to the estate had been a matter of public record throughout the probate process, and that our client had made no representations regarding the estate's liabilities in either direction. This was precise and accurate, and told Gerald Fitch exactly nothing useful. He asked 2 more questions in the same careful, probing way. About the deferred tax schedule, about the LLC's liability register, and Patricia answered each one with the same steady, factual courtesy. When the call ended, she sent me a single message. It had landed. I thought about Lawrence reading that document, not with satisfaction exactly. Satisfaction implies something warmer than what I felt. It was more like the particular stillness that comes when a long calculation finally resolves. When the numbers you have been carrying in your head for 2 years appear on a page exactly as you knew they would, and the outcome is precisely what the math always said it would be. He had signed for everything: the contamination lien, the deferred tax liability with 4 years of accrued interest, the dormant vendor dispute, the subrogation claims, the defaulted promissory note, the LLC's entire liability register, line by line, now legally and solely his. Gerald Fitch had built his case on Dowell's numbers. Dowell had only counted what was coming in. Gerald Fitch requested an emergency meeting with Patricia the following week. He came with Dowell and a younger associate who took notes and said nothing, and he laid out what they had found in the disclosure package with the careful, flattened tone of a man who has recently understood that he missed something significant and is now managing the consequences of that professionally. Patricia listened. I was not in the room. There was no reason for me to be, and some advantages to remaining at a distance. But she gave me a full account afterward, precise and unhurried, the way she delivered everything. The contamination lien on the Delwood Avenue property carried a remediation obligation that the Environmental Authority had now formally assigned to Lawrence as the recorded owner. The 6-figure estimate from the Phase 2 assessment was a floor, not a ceiling. Actual remediation costs would be determined once the scope of work was approved, and the county's timeline was not flexible. Lawrence could not sell the property, refinance it, or transfer it until the lien was resolved. It was, for the foreseeable future, an obligation wearing the shape of an asset. The deferred federal tax liability had accrued 4 years of interest and penalties that brought the total considerably above the original figure. The IRS had a new taxpayer of record. They had already been in contact with Gerald's office by the time the meeting took place. The LLC's liability register, the vendor dispute, the subrogation claims, the defaulted promissory note, had been reviewed by Gerald's associate and confirmed as active and enforceable. The LLC's most solvent operating account and its 2 strongest performing properties were not part of the estate. They never had been. They had been transferred into an irrevocable trust 26 months before Eleanor's death, properly executed and recorded, predating the revised will by 18 months and outside the reach of probate entirely. Gerald asked Patricia whether there was any basis to challenge the trust transfers. Patricia told him that her client's mother had established the trust while living, competent, and under no duress, with independent legal counsel, and that the documentation was thorough and unambiguous. She said it pleasantly, without emphasis, the way you state something that does not require argument because it is simply true. What Lawrence had inherited was real. Every liability was legitimate, every obligation legally his. He had signed for it completely and without reservation, in a room he had chosen, with a pen he had brought himself. Eleanor had not hidden anything from him. She had simply built something he was never meant to keep, and made sure, quietly and early, that the right person would. Lawrence contested. This was not surprising. It was, in fact, the only move left available to him, and Gerald Fitch, whatever his limitations as a careful reader of liability schedules, was competent enough to pursue it. They filed a formal challenge to the trust transfers, arguing constructive fraud, undue influence, and a handful of other theories that looked more substantial on paper than they were likely to be in front of a judge who had seen the documentation. Patricia assigned the response to her associate and went on a scheduled vacation. That is how concerned she was. The review took 11 weeks. Lawrence's legal team examined every transfer document, every notarized signature, every date stamp, every communication between my mother and her estate attorney that could be obtained through discovery. They were thorough in the way people are thorough when they are hoping to find something and becoming gradually aware that they will not. Eleanor had worked with her attorney over the course of 8 months before executing a single transfer. She had been examined by her physician and declared competent. She had signed nothing in proximity to Lawrence, nothing under time pressure, nothing that could be characterized as anything other than a deliberate, informed decision made by a woman who understood exactly what she was doing. Every transfer predated the revised will by 18 months. The challenge was withdrawn quietly on a Tuesday, which felt appropriate. No hearing, no ruling, just a notice of withdrawal filed with the court, and a brief call from Gerald Fitch to Patricia, confirming that his client would not be pursuing the matter further. Patricia thanked him. That was the end of it. I used the trust assets the way my mother would have used them, carefully, without drama, with attention to the long view. The 2 properties needed some work, and I did the work. The operating account became the foundation of a restructured LLC, re-registered in my name, with a liability register that started clean and stayed that way. I hired a property manager my mother had trusted and kept the Sunday morning habit of reviewing everything myself. Eleanor's original LLC operating agreement, 12 pages, her signature at the bottom in the same careful handwriting as the notebooks, I had framed. It hangs in my office above my desk, next to a photograph of her at the kitchen table, glasses low on her nose, tea going cold beside her. Lawrence and I have not spoken since the challenge was withdrawn. I have not called him. I don't expect that I will. There is nothing left to say that the numbers haven't already said more clearly than I ever could.